Hello, ladies and gentlemen, and welcome. This is William Heineman, your host, and this is Just Force 911, where we look at how our public officials do their job or they completely and totally screw it up. Hey guys, this one here comes from the Junkyard Dog, and it's about attorney that the cops lied. Gee, there's something new. They misrepresented. They decided they didn't need a warrant. They broke into the attorney's house and arrested her. And yeah, it's typical crap from scumbag cops. You know, it never ends. So do me a favor, subscribe if you would, please. I thank you very much for those who have subscribed. Hit the bell icon so you know when a new video comes up. Share and like because it helps my algorithms. Anything else? Oh yeah, thumbs up, thumbs down says how I do, and leave a comment. And then if you would go over to the Junkyard News, and tell them I sent you guys over there and check them out. They have a lot of good stuff. You might like it. Let's go ahead and get this video started, shall we? And I won't be able to stay out of it, but I'll try my very best.
Show up, police!
Gentlemen, do you have a warrant?
Hello everybody, and welcome once again to today's video here on the Junkyard News. And in today's video news story, we are going to discuss a case in which an attorney just received the settlement of $760,000 paid by the city's insurance, and the public was assured that no taxpayer money would end up going towards this settlement. But the brunt of the case and the discussion we're going to have today is when police misuse the community caretaker exemption to the Fourth Amendment to try to get around a search warrant. It not only erodes the public trust, but the constitutional protections safeguarded in our Bill of Rights. This video is about Stephanie Rafkin, a 64-year-old attorney from Shorewood, Wisconsin, who found herself at the center of national attention after a dramatic confrontation with law enforcement. See, the ordeal began during the heated Black Lives Matter protests back in June of 2020, sparked by the killing of George Floyd. Rafkin, upset by the gathering outside her home, confronted a group of protesters, which included a 17-year-old organizer. A tense moment escalated into a physical conflict when she pushed the teenager, all caught on cell phone video. The incident captured on the video quickly went viral, drawing widespread condemnation. What followed, however, was just as controversial. You see, police arrived at Rafkin's home the next day to arrest her for assault. But she refused to cooperate, locking herself inside her home, knowing that the police would need a search warrant to enter her home. Police stood outside her home for nearly 30 minutes, knocking on the door, walking around the property, trying to get her to come to the door, and on body camera you actually hear an officer says, when she comes out, we're going to arrest her. No question.
To arrest her.
If she comes out, arrest her.
With no mention of obtaining a warrant.
She comes out, we're going to cuff her and stuff her. But she didn't come out. She ignored the police attempt to get her to the door and open the door. But after 30 minutes, a neighbor came up to the officers and tried to explain, you know what, it's possible she's sleeping. She told me on the phone a while ago that she's been having trouble sleeping and she took a sleeping pill about 12 hours ago. And that right there led the police to concoct a scenario to try to get around a warrant to enter the premises. You would think in that 30 minutes that they would have time to call a judge and get a warrant to enter the premise to effect.
And they didn't get around it because they had to pay $760,000 out for their misbehavior again. Why doesn't this come out of these cops' pensions? That's what I want to know. You know, the insurance company paid for it, great, okay? But how many of them don't, where the citizens have to pay? Let these cops start paying for it out of their pensions. Let's see how they like it then.
The arrest, knowing that she was, in fact, inside. But instead of jumping through that legal loop, they decided, hey, we need to make sure she hasn't overdosed on sleeping pills. We're going to enact the community caretaker law, the exception to the Fourth Amendment, to bust in her door and make sure she's still alive. Stephanie, of course, was alive as she came downstairs and asked the officers, "Do you have a warrant to be in my home?" To which the officer says, "Oh, we're acting as community caretakers." And she said, "Well, as you can see, I'm alive, I'm fine. You can leave my house now."
Gentlemen, do you have a warrant?
We're here for a community caretaker, okay?
Community caretaker, I'm perfectly fine. I am sleeping.
where she was arrested in her dining room.
Turn around for her. Put your hands behind.
See, these are the kind of scumbag cops that get other good cops hurt. You know, they're like mindless drones. They have 20 IQ. You know, they're a bunch of morons. They don't care. You know, we're just doing what we're told. Didn't Hitler say that same thing? I think he did. Anyway, here we go.
Thank you.
You're gonna arrest me in my own home? No.
Don't start.
Don't.
Got it. Yep, I got arrested.
But since they were already inside, using the community caretaker exception to the Fourth Amendment, they then placed her under arrest, and that is at the crux of her lawsuit. Now, this case raised eyebrows, not only for Rapkin's actions from the previous timeline, when she spit on a protester who was 17, which started all this, but for the heavy-handed tactics used by law enforcement to effect an arrest. Critics questioned whether the community caretaker justification was misapplied, as there was no apparent immediate danger. The incident became a flashpoint in debates about race, policing, and civil liberties, leaving behind a complicated legacy of mistrust and legal challenges. You see, police circumventing the Fourth Amendment by misusing the community caretaker exception to enter a home under false pretenses is blatantly wrong, because of course it undermines fundamental constitutional protections. The Fourth Amendment protects individuals against unreasonable searches and seizures, requiring law enforcement to obtain a warrant supported by probable cause before entering a private residence. Exceptions, such as community caretaker doctrine, are narrowly defined and intended only for situations where police must act to protect public safety or prevent imminent harm, such as welfare checks or emergencies unrelated to criminal investigations. And that's the key, unrelated to criminal investigations. When police try to circumvent the Fourth Amendment by abusing the community caretaker exception, police sidestep the safeguards that require judicial oversight. The warrant process exists to prevent arbitrary and unjustified intrusions into private homes, ensuring law enforcement actions are based on valid legal grounds rather than subjective judgments or convenience. Because we all know, even though the public trust is at an all-time low, when police misuse exceptions, it diminishes trust even more in law enforcement. Communities rely on assurances that officers will act lawfully and respect constitutional limits.
Are you stupid or something?
Violations create fear that rights can be disregarded at any time, especially in contentious or politically charged situations. Courts have repeatedly emphasized that the community caretaker doctrine is not a catch-all excuse to bypass the Fourth Amendment, as in Caniglia v. Storm back in 2021, where the U.S. Supreme Court clarified that the doctrine does not allow warrantless home entry outside genuine emergencies. Misapplication of this rule directly contradicts established legal standards to enter a home without a warrant. And if we allow law enforcement to stretch the definition of the community caretaker doctrine, it creates a dangerous precedent. If officers can justify forced entry for questionable reasons, it opens up the door to more frequent abuses, eroding civil liberties even more and weakening the rule of law. And in the case of Stephanie Rapkin, there was no evidence or immediate danger to herself, others, or public safety that would justify invoking the community caretaker exception and using it not only to break down her door, but arrest her and use it as a pretext for a criminal arrest, as that misrepresents its purpose and contravenes constitutional protections.
But guys, keep in mind, this is the kind of scumbag cop attitudes that these cops today have. You know, they can do whatever they want because they think that they're immune, because they're qualified immunity. And the thing is, their qualified immunity is disappearing very, very quickly, and should. You know, it's going to be pretty soon where, you know, qualified immunity is going to be gone, and these clowns are going to start being held accountable.
Let me finalize by saying misusing legal exceptions to justify warrantless entry is an affront to the principles of justice and due process. The Fourth Amendment is a cornerstone of American freedom, especially in one's home, and circumventing it under false pretenses betrays both the letter of the law as well as the spirit of the law. Thank you again for tuning in to this video by the Junkyard News. Be careful, people. I'm telling you, or the next video we cover on here, the next news story, we're going to be talking about you in the next one. Thanks again.
Stephanie.
And keep in mind, they abuse their power all the time. This is not something new. This is not something that, we're just now finding out about. This happens all of the time. And it's these scumbag cops that, do this. And they need to go away. They need to be gotten rid of. Get rid of the bad unions. Get rid of the sheriffs that are corrupt. The police chiefs that are corrupt. Get these police officers under control and have them start doing their job. They are public servants. Public servants. They are there to serve the public. Guys, have a great and wonderful day, and I will talk to you guys on the next one. Ciao.